Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. I'm one of your hosts, Marcy Dixon. Thank you, Jennifer, Matt, and Steve, for being here. As you know, Miles Mediation and Arbitration recently rebranded, and one of the things that we're deeply committed to is taking alternative dispute resolution, ADR, back to its original principles and promise. And in the context of arbitration, this includes realizing economy and expedition for clients, encouraging creativity through the process, and empowering parties in conflict to take control of their disputes. So with this in mind, Matt, Steve, Jennifer, how do you prepare clients for the arbitration process, particularly when clients prefer litigation over arbitration sometimes? And how critical is it to pick the right arbitrator?
Well, I think the selection of the arbitrator is key, and it's really can have the biggest impact on what the outcome of the arbitration is. It's very important to select an arbitrator who is competent, but who's also going to do an excellent job, who's going to handle the arbitration in an efficient way, and who's not just going to split the baby.
And I think that the selection of the arbitrator not only impacts the outcome, but it significantly impacts the process. And you can have an arbitrator that helps empower the parties to create and control their own process through the dispute and craft the dispute in a way that works for them. Or you can have an arbitration provider that, instead of doing so, kind of I almost just empowers the provider, but takes their processes and kind of shoves it onto or pushes it toward the parties involved in the arbitration and forces them to come within the constraints of their idea of what the arbitration should be, instead of allowing the parties themselves to control that process.
And how much do you prepare clients for that, though? I mean, some litigants walk into the process with no idea what to expect. So how exactly do you prepare clients for the process?
Well, I think from the client perspective, they have to understand that the reason that they're involved in the arbitration at all is because of a contractual agreement that they entered into at one point in time. So they have to understand the why as to the how they got to where they are today. But then to understand the difference in arbitration versus the litigation process, to explain to them that as I think everyone in the room is concerned with, is returning arbitration back to what ADR was originally intended to be, to help provide a more cost-effective, speedy, more controlled process to allow them to resolve their dispute, and how they can work within the realm of that arena to actually achieve that, to provide themselves benefits over litigation that they wouldn't have otherwise available to them. And then to explain to them that, yes, you're giving up some things by going to arbitration, but you're also supposed to be gaining some things by going to arbitration, and working with them to make sure that when they go through that process, they are working towards those gains instead of only getting with it the stuff that they gave up by going from litigation to arbitration.
Marcy, in a real sense, there really isn't a particular advantage to arbitration over litigation as a dispute management process unless you realize economy and you realize some kind of efficiency. Everyone has to acknowledge that at least one of the challenges associated with arbitration is that sometimes you are leaving the decision about how the dispute's going to be resolved in the hands of one person. There's some risk there, even risks that are greater from time to time than you would in putting the dispute in the hands of a 12-person jury. There's also the downside risk in arbitration that courts are so anxious for arbitration to flourish and so anxious to promote arbitration because the court's interest is in having less litigation, having dockets that are less full of particularly civil matters to resolve, that any arbitration result that you get, an arbitration award, is going to be very difficult to overturn. It's very, very likely that an arbitration award is going to be confirmed by a court. Well, given those downsides, I think the way to counsel a client around what arbitration is supposed to be about is that you can really and truly capture for yourself benefits that outweigh those risks but only if you give strict attention on the front end to the process. And that starts with turning loose of any sense that the parties to an arbitration are somehow bound by some prior agreement or by some process that is put in place by an arbitration company, or any reference in an arbitration clause to a particular arbitration company or a particular set of rules. I think it is empowering for my clients when they hear me say, look, there are some downsides to arbitration, but one of the great upsides is that you can take a look at this particular dispute and you can, with opposing counsel, come to a place where you can agree to how the process best suits this particular dispute. You can figure out a way, whether it amounts to changing an arbitration clause or rewriting the process that was put in place in advance to best suit the party's needs and to realize some efficiencies. The last thing in the world I think a party needs is for their outside counsel to show up with their litigator hat on rather than an arbitration advocate hat on. And I think that begins at the very beginning of the process.
I think that's a great point, Steve, about the parties being able to take control, even though they have that arbitration clause, and to depart from that, because you may have, I've seen instances where an arbitration clause has a specific forum specified, an entity through which the parties are to arbitrate. And the parties have discussions through their lawyers about the fact that maybe this is not the best avenue for us to go. Maybe this particular company is not one that we both agree wouldn't be best to handle this for cost-wise or efficiency reasons. And so therefore, we are going to agree to use a different arbitration company or a different arbitrator altogether. Have you seen that, Matt?
Absolutely. I think that's a great point, Jennifer. I think that oftentimes as Steve kind of put it, it's the founding block for the arbitration, but it's not necessarily the definition of what's going to happen in the arbitration. And the parties, in many cases that I've been involved in, will see the arbitration clause. They'll see that it does call for a specific provider, and will ask me, is there anything we can do about this? Are we stuck with this option? Are we required to go through this company and go through their process and use their rules? And the answer is, if the other party will agree that it's not in the best interest of both parties to proceed in that manner, you can select an arbitrator other than what's in the arbitration provision of your contract and go that route and change the process. Selecting an arbitrator that your lawyers feel confident have the particular competence to handle your dispute, have the confidence that arbitrator is going to actually make a decision that's going to be based on law and facts that are presented in your dispute, as opposed to, as I think you said earlier, splitting the baby. You don't want to really have arbitration is not designed to kind of find the middle ground of what the number is in dispute and give that as the award. It's designed to resolve the dispute, and you want somebody to make a decision that's based on the facts and the law and come to an actual conclusion of the dispute. So I think, yes, Jennifer, absolutely. Parties oftentimes in cases that I'm involved in will look at the contract, say, I see that it calls for this. Are we required? And the answer is, typically no. If you have opposing counsel that's willing to work with you, you can find a better solution than what's usually provided in the contract.
And I think that is a starting point for parties to have those conversations, because I've found that a lot of clients didn't even realize that they agreed to arbitration at the time they signed the contract, or they may not have understood what the arbitration clause meant or what the ramifications would be. And a lot of them don't have any idea what the arbitration company is like. They don't know what their reputation is in the industry. They have no grasp of what the fees could be associated with that arbitration. And so it's an eye-opening experience for them when they first start having these conversations with their lawyers and they didn't realize, oh, I agreed to that company, to select that arbitration company when I signed this contract. I had no idea.
And as to the fees, in typical litigation, you're paying your lawyer, and maybe you're paying some expert witnesses, but you're not typically paying the court. So you're not paying your decision maker, and that's an expense that you incur when you go into arbitration. But if you can get time and other efficiencies created back to you from going through that process, then there may be times where it makes a lot of sense for the parties to pay a qualified person to sit in a room and make a decision based on experience and facts that maybe a judge or a jury wouldn't have the equivalent knowledge and experience to be able to handle, and wouldn't be able to get to you in a time that would make your dispute resolve in a fashion that needs to be for you. You may need your dispute resolved sooner rather than later, and if you're on a court docket that's just completely jammed full of cases, you may be waiting for quite some time before you ever get heard by the court.
One of the reasons I became a full-time arbitrator is because I found so many inefficiencies with the process. I've seen cases that have taken 1 to 2 years to arbitrate. I've seen cases where clients have spent hundreds of thousands of dollars in legal fees and arbitration fees to have their dispute heard. It has gotten so far away from the concept of what arbitration was intended for, and really to streamline the process and give the parties control over managing their disputes, and to come to an end in a much faster means than they could get in litigation, and from somebody who's very competent, an arbitrator who's experienced, who's handled these types of matters before, and is going to be fair and make the right decision.
Can we touch on fees for a second? Because it's arbitration is considered litigation light, mainly because of the excessive fees. So how appropriate is it for the arbitration provider to be upfront about the costs that could be incurred throughout the process?
Marcy, a couple things. One of the real challenges that arbitration has experienced in the last 20 years is an approach that's taken to arbitration by the participants, both by the parties and through the leadership of their outside counsel, in really acting as if arbitration is, in the expression that you've used, just litigation light. It's just like litigation, except that the scheduling parameters are softer, that the parties can agree to do this when they want to do it, where they want to do it. If that's the only way in which arbitration is going to be approached by parties and by outside counsel, it's going to be almost impossible for the parties to realize any kind of economy or any kind of expedition in resolving their disputes through arbitration. And what results, and I think the three of us have had this experience, we've had clients in private practice who have despaired at what they were getting out of arbitration, asking basically, where is the value proposition in arbitration? Well, the value opportunity in arbitration has to do with what we've already talked about, which is control. Clearly, the reason that litigation costs skyrocket is because the way in which the whole dispute resolution process is organized and controlled is out of the hands of the parties, and it's largely out of the hands of their lawyers. There aren't any efficiencies that can be experienced if you're on a docket with 1,200 other matters, some of which are smaller than yours, some of which are larger.
What are the best ways to control the cost of arbitration without compromising the fairness of the process?
It all comes down to process, as far as I'm concerned. Trying at the very beginning of the process to make reasoned decisions about how much discovery is necessary, making reasoned decisions about how the parties are going to manage the hearing, making some reasoned decisions about how best to use the arbitration process. I'll give you one small example that can be a very expensive mistake in arbitration. It is the case that arbitrators have the power to sign subpoenas. They're given that power by the Federal Arbitration Act. They're given that power by most state arbitration acts. Well, that's fine. That allows an arbitrator to assist the parties in gathering documents, in procuring the participation of witnesses at an arbitration hearing. But that's not the end of the inquiry. The fact of the matter is that while as an arbitrator I have the authority to sign a subpoena, I have no way have anything at my disposal to allow me to enforce a subpoena. I don't have an army. I don't have a sheriff's office. I don't have anyone who can go out and make anybody do anything. The truth of the matter is, if you want to take an arbitration subpoena and get it enforced, you're going to have to double back and go to court to do it. Well, that's not necessarily a problem if you start early. The challenge I see is that parties that don't plan properly and have me as the arbitrator sign a stack of arbitration subpoenas 48 hours before the hearing starts, oftentimes will come to me saying, well, this witness is saying that they won't respond to the arbitration subpoena. They won't come and testify, or they won't produce X number of documents. Well, I have to tell them that, sure, that there is a process by which we can compel them to respond to these subpoenas, but we can't do it in 48 hours. So your hearing date gets blown. Any efficiency that you've realized in terms of planning for when this hearing is going to take place and how long it's going to take goes right out the window. And that simply arrives from treating an arbitration subpoena as equivalent to a litigation subpoena when it's simply not. Those kinds of inefficiencies can be avoided, but they can only be avoided on the front end. If you're going to do some planning at the initial arbitration conference about how you're going to manage discovery, I always encourage parties to take a very, very hard look at the very beginning of arbitration to decide what it is they're going to need in the way of assistance, what it is they're going to need to do by way of collaborating with opposing counsel to make witnesses available in order to avoid those pitfalls. And to remind them that if they need me to sign subpoenas, it's better to have me sign subpoenas 3 or 4 months before the hearing rather than 48 hours before the hearing. There is enormous economy that you can realize in arbitration, but only if you plan ahead and only if you are encouraged by an arbitrator to understand that you've got the power to make your own rules.
I think communicating with clients about the cost of arbitration up front is very important, because I think a lot of clients don't understand the costs associated with arbitration. I know that there are some arbitration companies that charge very hefty upfront filing fees. Obviously, we don't do that here, but it's important for a lot of people to know that up front when they're communicating with their lawyers about getting the arbitration process started and what it looks like cost-wise. That's so important. John Miles got a phone call one day and said, "Can you come to our office and sit down with these parties quickly, please?" And he said, "Sure." And he went there, and what he discovered was that both parties were in a business dispute, business divorce, and LLC was breaking up. And the two parties had an arbitration clause in their contract. The two parties followed their arbitration provisions, and they had another entity, an arbitration company, not Miles, who was handling the arbitration. The arbitration is about to commence, and both sides are sent a very large invoice to pay in advance of the hearing. And both parties at that point said, "Whoa, wait a minute here. Let's see, before we embark on this, if we can use these resources that are going to be paid for this arbitration to try to resolve this." And John was asked to come in and mediate that on the eve of that arbitration, and the case actually got resolved. But in that instance, both of those parties had been surprised at this hefty fee that had come in up front that they really weren't prepared for. Maybe the arbitration company hadn't told them about in advance. And so you definitely don't want to have your clients be surprised about that. And it's important to know about those, for the arbitration company to be communicating about those on the front end.
And not only what the fees will be, but when will they be assessed? I'm representing a client in a case, and my client would have recently paid a large amount of money for his expert witness, and then all of a sudden, within a couple of weeks, he gets another invoice, but this time it's for the arbitration hearing, and it's from one of the large providers, and it's a fairly hefty invoice, and timing wise and cash flow wise, you're usually dealing with these businesses that they don't want to be shelling out $50,000 left and right to deal with an arbitration matter. They want to do it efficiently, and the arbitration provides this promise of efficiency. And now all of a sudden, within a very short period of time, they've got to shell out a lot of money to keep going with this process. And I think the failing in that particular situation is that the arbitration provider didn't clearly provide information as to when money would be assessed for the file. So would you be getting an invoice early on requiring you to make a deposit for the arbitration hearing? Would you be getting it, in this particular case, it's a couple of months out that we're getting the invoice? And at this point in time, it's a little bit of a surprise to see the number, but I think timing of fees, the amount of fees, the process itself, all of these things are things that need to be kind of clearly identified at the beginning. I think Arbitration Management Conference can do a lot to help with those processes. And then I know Steve recommends that the litigants come with their parties to, or excuse me, the attorneys come with their parties to those conferences, because I think at that point in time, it's not just about the attorneys controlling the process. The parties themselves need to have the input into that process, and not just the input and the control that we're talking about, but awareness. Sometimes it's an education process for them to attend something like that, just so that they understand, 3 months from now, this is what's going to happen, or next week, this is what's going to happen. But it's not a surprise when it happens. It's just something that they kind of built into the process so that they understand. And understanding the process, I think, goes a long way to keeping clients happy as they go through that process, because they know what's coming. You can budget for it, you can plan for it, you can be ready for it, and then when it comes, it's not a surprise. Surprises, I think, are the thing that really catch the parties in arbitration off guard.
Absolutely. Setting those expectations up front is very important.
There's absolutely no reason at all, if you're going to arbitrate, for anybody to be surprised by anything. Let's look at it this way. You're participating in a process where the rules are set by the parties by mutual agreement. Well, that's completely inconsistent with entering into a process where you find yourself right and left being hit with things you didn't anticipate. It's really not very complicated from the services provision standpoint to help the parties get a pretty good fix on what their out-of-pocket costs are going to be for doing an arbitration. Administrative fees, quite honestly, can be quantified up front fairly easily. Once an arbitration is underway, it's not as if I'm the arbitrator, that folks in my shop at Miles Mediation, I don't have dozens of bureaucrats who are bustling around all day, every day to keep the arbitration going. The arbitration is kept going by the parties, and the parties participating. If they have a dispute in discovery in advance of a hearing, they can always bring that to my attention. But quite frankly, my participation is something that they can gauge for themselves. I don't have to be involved, and my staff doesn't have to be involved day in and day out in the arbitration. Same thing with an arbitration hearing. An arbitration hearing shouldn't be a Perry Mason exercise or a TV lawyer exercise where people are caught out and people think that they're going to give opening and closing statements and stand on their head. Primarily, an arbitration hearing is about record creation. It's about making sure that everyone gets to have in the arbitration record everything that they want. And there's no reason why that can't be done with a considerable amount of planning and a few surprises.
One thing I think that gets lost in the arbitration process is mediation. I think when clients come in and they have a contract that has an arbitration provision in it, they automatically assume, so we're in ADR, so we're going down an ADR path, and they seem to forget. And sometimes when you suggest to them that maybe they ought to consider mediation as well, that they think that you're somehow double dipping the process with them, or that why would I mediate a case if I'm in arbitration? And I think that, making clients understand the distinct differences between the two and the distinct benefits between the two, they're very, very different. And I think even if people have been through the process, sometimes even confuse the terminology of mediation and arbitration, not understanding that mediation is a working towards a solution in an informal process that doesn't bind you to a decision, whereas in arbitration you've got a decision. And I think that parties in arbitration can definitely benefit from mediation, sometimes very early on mediation, because oftentimes those cases are the cases that have what I would consider a very closed universe of facts. And that's one of the reasons that arbitration can be efficient as well, because of the closed universe of facts. But one of the things that I think that parties sometimes just miss is, well, if we're in ADR, we're in ADR, so we don't need to mediate. And I think a lot of times you can get through the process just as quickly as you could by being ordered to be in a mediation by a judge, by saying to yourself, to your client, to opposing party, maybe we ought to take a minute, sit down, have a conversation, have a third party sit in here as a neutral and help us work through this. Maybe we can avoid even the more efficient process of arbitration by going to an even more efficient process that is provided through mediation.
That's certainly something that the arbitrators on our panel have done before. I've heard of our neutrals going in and suggesting mediation instead of arbitration. And that's just a good point. And I just wanted to sort of reinforce that is an option, because I think people forget that, you're not bound to the arbitration process, right? You can opt out early on. Is that correct?
Yeah, well, Marcy, I think an even more important point is to observe that there's nothing about arbitration that in any way excludes mediation as a process that might be of assistance in allowing, again, the parties to manage their dispute. There could be particular issues. For instance, I've been involved in arbitrations where the discovery, particularly the electronic discovery aspect or feature of the discovery in the arbitration, got very, very complicated. And a mediator was called in to mediate a dispute about discovery. I think what's incredibly important for parties to understand is that while mediation can be a vitally important tool in managing their dispute, even in the midst of arbitration, that if they're going to decide to mediate the entire dispute or mediate some particular feature of the dispute in the midst of an arbitration, they're going to have to hire a separate neutral to serve as their mediator. Their arbitrator isn't in a position to serve as their mediator, and if they ever encounter an arbitrator who volunteers to become a mediator, they need to realize that that's simply not workable. It's not workable because a mediator, in order to be effective and in order for the parties to actually mediate, they have to have confidential access to the mediator, to the neutral who's helping them facilitate a resolution to a particular dispute. An arbitrator doesn't have confidential access to either party. And once the neutral who is serving as an arbitrator changes hats and enters into these confidential, transparent conversations with the parties by way of trying to help them mediate a particular dispute, they're not able to put their arbitrator hat back on. You don't want an arbitrator showing up to manage an arbitration hearing and make a final decision and an award who's had any kind of basis for forming that decision or award that includes things that aren't in the record or includes private conversations that were had in bits and pieces in the context of a mediation.
Thank you for clarifying that, because I've definitely heard of that happening. I mean, I've definitely heard of an arbitrator switching hats and offering to be the mediator during the same process.
And I've had counsel request that we use the same neutral for mediation as arbitration. And as Steve has mentioned, I've never agreed to that. But I think it goes to something that you discussed in the previous episode as well. You talked about this concept of ex parte communications with an arbitrator, and if the arbitrator switches into that mediation role, it's inevitable that is going to be almost parallel to an ex parte communication when they're having those conversations. So it just creates a conflict there that that makes a very unworkable situation and puts the arbitrator, frankly, it puts the arbitrator in a bad position as well, where they're trying to say, okay, this was this conversation over here, I can't consider that. Well, how do you really put the
Matt, I'll give you an example. 2 weeks ago, in a matter in which I'm serving as an arbitrator, we had an initial arbitration conference in which it became clear early on in the conference that the particular arbitration we were there discussing had very, very close similarities to 4 other arbitrations that were pending, in which I'm also serving as arbitrator. And so the discussion between the parties, I think, quite reasonably moved in the direction of whether there is a way to aggregate the dispute in terms of how it gets resolved. They weren't talking about mediating any of the 5. They were talking about, is there a way to take these 5 arbitrations and to realize some economy in managing them together? It was exactly the kind of conversation that you would want parties to be involved in at an initial arbitration conference. And so by way of facilitating that discussion as the arbitrator, I asked questions. I sort of drew the parties out around what they thought was similar about these particular claims and defenses. And I put them in the position where they needed to consider 4 or 5 different questions on their own in conference with each other about whether or not these arbitrations were as similar as they thought. And if they were, what kinds of combined treatment could they decide on for these 5 arbitrations? And so we left the arbitration conference, and they met with the parties for all 5 of the arbitrations and came back with a communication to me that what they wanted to do was to combine all 5 and have one hearing. And so I drew up an order reflecting basically a joinder of all 5 of these arbitrations into one collective arbitration with one docket number on it. And I sent that back to the parties with a note saying, here is a draft order consolidating all 5 of these arbitrations for discovery and for hearing. But I think you need to go back into conference and you need to discuss among yourselves whether or not you want one award or whether you're going to need a separate award for each arbitration. And if you're going to need a separate award for each arbitration, perhaps you don't want to consolidate all 5 of these under the same arbitration docket number and have them be one large arbitration. You may want to keep these as 5 separate arbitrations, but just have one hearing. That's a kind of dynamic process where there's no ex parte communication. They're doing all the work of discussing what they want to do to realize what they need to realize and reporting back to me as the arbitrator as to how to reflect that in an order. It is not impossible for them to get back into conversation, and they haven't come back to me yet. If they reached loggerheads about how to move forward, it's not impossible for them to realize that it could be efficient for them to pay a mediator for an hour or 2 to come in and help them discuss how they want to sort this out. And then having done that, report back to me as to what they want the arbitrations to look like.
But going back to what you were saying before, it wouldn't be efficient for you to be the mediator because then you've switched hats and it's impossible to switch back into that.
Right. It was very apparent to me in the midst of that initial arbitration conference that if I wasn't careful, I could get drawn into a mediator's role of offering different scenarios, advices, et cetera. All I could really do meaningfully as an arbitrator is to suggest questions for them to discuss among themselves, draw out from them questions about why it is they think these things might be subject to being consolidated, and sort of empower them to have some greater understanding about how to work out between themselves a process that allows them to realize some economy and some efficiencies. I can see at many different points along the way as an arbitrator, parties having a sense, maybe part of this litigation light sensibility, that, oh, well, this is so informal and this is so non-litigation-like that I can just ring up the arbitrator, or I can shoot the arbitrator an email and get guidance about this, that, or the other. Nothing could be further from the truth. The arbitrator is not in a position to have ex parte communications with either of the parties. And I think if the dispute is large enough and the economy of the dispute would accommodate spending some amount of money on another neutral to serve as a mediator, I think that you could realize great efficiencies that way.
Our conversation will continue in the next episode. I'm Marcy Dixon. You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution at Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast or Spotify and subscribe, rate, and review this podcast. Join us soon for another interesting discussion. Thanks for listening.